Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, I am very pleased to announce that today we're going to have a very special show. If you all remember, I had Rosalind Duke on my show just last week, and this week I am bringing on a brand new guest. This is a guest who I would like to call an old friend. I don't know if he would be able to say the same or would want to, but I guess we're going to find out in due course. His name is Mr.Bederow, and you may remember him. He has made multiple appearances on The Young Jerks last year during the first Karen Read trial. Mark is a lawyer practicing out of New York, and he's going to tell you a little bit more about himself when I bring him on in just a few seconds. Mark has been following the Karen Read case, the first Karen Read case, and not only is he following the second Karen Read case, there are certain questions I'm not even going to be able to ask him because he actually has involvement and actually filed a motion for pro hac vici, which is a fancy word for a motion to practice law in a jurisdiction where you don't have a license just for one case. And Auntie Bev denied that motion just about a week and a half ago. He can tell you more about that. So without further ado, I bring you Mark Bederow. How are you, Mark?
I'm okay. How are you?
I'm doing good, man. So tell us, how did you get into this case in the first place?
How did I get into this case? Well, I'm from Massachusetts. I obviously practice in New York, but I follow local news. And I think anybody from that area was interested in a case where a finance executive type woman was accused of mowing down a police officer boyfriend who was found dead on the lawn of another police officer. And if you practice criminal law for a living and you're from that area, it's going to be an interesting case. So I followed it casually, just, reading about it casually in the news. And as time went on, it became more interesting, certainly when there were all kinds of allegations where there might have been, people in the house involved, makes it more interesting. And followed it a little bit more closely than that. An old friend of mine who's a lawyer from where I grew up keyed me into some legal analysis that was pretty absurd about the case going on from a local attorney. And I just started kind of responding to her nonsensical tweets, and that for whatever reason attracted some attention.
For some reason, the obvious reason. Go ahead.
People reached out, started sharing views, and that gathered people's interest, and just continued to talk about it, learn more about the case, shared my view, triggered a lot of people for, having the temerity to have an opinion that was different from their own. And
how
from
dare
there,
you, Mark, for having an opinion that disagrees with theirs?
After the first trial, I got retained by Aiden Carney, who I'm sure a lot of people are familiar with, to assist in TurtleBoy, to assist in his defense, was admitted in Massachusetts pro hac vici. No problem in that case.
Hold on. So let's take a step back. When did this happen? When did you get into TurtleBoy? Which case was this? This was the witness intimidation case in Massachusetts against TurtleBoy, right?
It is. A couple of witness intimidation cases where he is alleged to have overstepped his bounds as a journalist, reporter, blogger, whatever you want to call it, and is alleged to have intimidated witnesses in the case by confronting them, asking them questions, speaking his mind, things that most people have never heard of, and things that would not happen pretty much in any state other than Massachusetts. But I got involved in that case, which drew a little more attention. And as of several weeks ago, I had been engaged by Karen Read to help her in her retrial.
Okay, so hold on. Let's take a step back. Let's unpack this real quick. So over the summer of last year is when you joined forces with Bradel to represent TurtleBoy in his witness intimidation charges in Massachusetts.
Yeah, I think that's right. Obviously have it in front of me, but I would say sometime in July. That sounds about right.
So right when the Karen Read case comes to a conclusion, mistrial is declared. You, at some short time after that, you joined the fray in defending TurtleBoy.
Correct.
What inspired that?
Well, in the first instance, I mean, I was asked to do it, and it's an interesting case. But if you have the kind of interest that I have, big proponent of the First Amendment and journalist rights and the public's right to know, he's an interesting person. Some people hate him, some people love him. On the other hand, he's, really cast a bright light on what appears to be a very troubling case. And to see him prosecuted by the very people that he's criticizing for disagreeing with their view of the case and bringing them, I'm sure, a lot of heartache. As a lawyer, that's the kind of case you want to get involved with. There's something very Orwellian and troubling about the concept of the government going after a journalist for, allegedly intimidating witnesses because they don't like what he's saying. It's very content based. And, in terms of digging deeper into what the charges were, in looking at the Massachusetts statute at issue here, it's very unique. Their witness intimidation statute is basically anyone who causes a witness or a family member any degree of emotional harm, whatever the hell that means, subjectively to the witness, is liable to be prosecuted for that case. The cops can say if your intent was to somehow, rig the trial or get them not to testify and you cause them emotional harm, you can be prosecuted. In most states, as you know, those kinds of either tampering, obstruction, or witness tampering charges, whatever you want to call them, generally will involve offering bribes, threatening to break kneecaps, threatening to release humiliating information, not expressing viewpoints that certain people that are not charged may in fact be guilty, or confronting them with a microphone to ask questions or even share your view about them. That happens all the time. But in Massachusetts, with the state police, who are, again, highly interested in seeing Karen Read convicted, are the same people who went after him for, sharing a viewpoint that's different than their own, albeit some would say in a very obnoxious way. But, obnoxious does not equal criminal. And that's really the problem with the Massachusetts theory of their cases against him.
I couldn't agree with you more. So obviously, I'm not going to ask you to go into details. You and I both being practicing attorneys, we know how sensitive it is to protect client information and not to disclose any details of the representation. But just in general terms, how would you say the prosecution and the defense have been progressing in that case over the last 7-8 months since you've joined?
Well, they move very slowly, which I think is actually part of the point. I mean, you wonder how invested are they in really prosecuting him for what most people think is nonsense or certainly aggressive, or is the goal of the exercise here to silence him, to stifle his speech and keep him from reporting, on the Karen Read case? I mean, a perfect example is Karen Read's retrial is scheduled to start in 2 days. They have put Aiden on their witness list, their prosecution witness list, no doubt in an effort to keep him out of the courtroom as a journalist, and perhaps to even, sequester him to avoid him from having his very highly successful show certainly during the trial. And those are issues that we're going to be dealing with in very short term as it relates to him. But, these cases generally are just kicking the can down the road. They seized his cell phones upon his arrest in October of 2023, and claimed they were unable to search them for approximately a year. They were in no rush to do anything with him. So,
do you think because his case is in many ways intertwined with the Karen Read case, they have no interest in resolving it quickly? They want to drag it out to make him sheepish about covering this case and so on. What is your opinion on that, if you have one?
Yeah, I mean, I think certainly they want to stifle his speech and keep him concerned about potentially being jailed, rearrested, and that if you cover this or, do your aggressive form of journalism, that you'll get in trouble. And certainly I don't think the prosecution wants to rush to try him for the simple reason that the witnesses against him are, for the most part, critical prosecution witnesses against Karen Read. I mean, you're talking names like Jennifer McCabe, Brian Albert, Chris Albert, Colin Albert. I mean, Michael Proctor, Yuri Buchanan. I mean, these are the named witnesses against him. Anyone who follows Karen Read knows how significant those people are in the case against her. Certainly, I don't think they want them being subjected to cross-examination and very vigorous cross-examination in Aiden's case beforehand.
Exactly. And I'm glad you brought that up because I was I can do a little plug of my own here. I have covered a lot of those cross-examinations on my channel. I have playlists. Chat, you're more than welcome to check them out. We just concluded the Yuri Buchanan series. That is going to be premiering over the coming weeks. And we just finished showing the Higgins series, and I have Matthew McCabe. Allie McCabe is already in the hopper. Jennifer McCabe, they're all posted. So go check those out at your leisure. Now, Mark, with respect to the last hearing that happened at Norfolk County Courthouse, and it may have not been, I shouldn't say the last one, but one of the most prevalent ones, and I think you know the one I'm talking about, one of the most recent ones, that the Karen Reed crew, Jackson, Yannetti, Alessi, and Little walk into the courtroom, guns a-blazing, saying, excuse me, the stuff that you are doing here is affecting our case, and this is the other judge. Judge Sisitsky is presiding, and this is TurtleBoy's case, and now all of a sudden Karen Reed is sitting right next to him, and we saw how that unfolded with the motion for cell phone records that the judge is like, well, what do you need? Why are you asking for them? How does that come into play in the litigation for TurtleBoy? And then we'll talk about Karen Reed.
Well, the interesting thing is, so that was actually on Karen Reed's case. That purpose of that hearing was in the form of a Rule 17 under Massachusetts Rule 17, which relates to trying to subpoena third-party records, things of that nature, cell phone records. So that was trying to get Aiden's records for use by the Norfolk DA's office, who was essentially recused from prosecuting him, but in Karen Reed's case. So the idea that they were not noticed for the hearing in their own case is outrageous. I mean, that's not my fight to bring, obviously, at this point. Sure. I only represent Aiden. I could have represented both of them, but that didn't happen. The point is, they had every right to be there, every right to sit there, every right to do what they do. And that's why I think when you saw that footage and you saw them look pretty pissed off and look over at the prosecutor, it's understandable why anyone would be pissed off if they were essentially not told or unaware what was going on in a hearing involving their client, and certainly ours as well. So they're trying to get his phone records, and that's all that hearing was about.
And how, when it relates to the Karen Reed case, so now let's talk about your pro Hac Vice status. You kind of touched upon the fact that you had no issue, right, back in July with Judge Sisitsky to enter a pro hac vici motion. Your Honor, I'd like to practice law in Massachusetts on this case. I'm a New York lawyer. Bradel is going to be my co-counsel. He's licensed in Massachusetts. He's my pro hac vici counsel. And the judge, did he give you any issue? Did he give you any problems with your desire to appear?
I don't even know if it was Sisitsky, to tell you the truth. I don't remember who rubber stamped it back then, because it was rubber stamped. And obviously, if you've been doing this for 25 years, licensed in multiple states, multiple federal jurisdictions, no ethical history. These are criminal cases. I'm a former Manhattan prosecutor. I've worked at a large law firm. I've had my own successful criminal practice for a number of years. Obviously, that is a rubber stamp situation. There's no reason to be denied pro hoc. And so ironically, in the same court that Karen Reed's in, I had no problem getting admitted in Aiden's cases. That was rubber stamped as it should be, for sure.
And what happened with the Karen Reed situation a couple of weeks ago?
Well, according to the court, she is of the belief that there was an unwaivable conflict, which of course I have a strong disagreement with. Now, obviously it's her court. She can do whatever the hell she wants. And, someone like me is going to follow that. But, when you have, as you know, any possible conflict of interest, given that, Aiden covered Karen's case and there's some overlap in witnesses, and at one point the prosecutor attempted to indict them for conspiracy to commit witness intimidation. What I'll tell you is this, without going behind the curtain and getting into conversation specifically, when you have what I'll call a possible conflict of interest, even if you don't believe there was one existing at that time because the client's interests are not unaligned or whatnot, it's very simple. You meet with each client, you explain to them the possible conflicts of interest, what that could mean.
Exactly.
I did that with both of them. I sent both of them to talk to their other lawyers outside of my presence to speak very candidly, to ask any questions or concerns. Neither the lawyers or clients for either of them had any concerns. The next step is you create what's called an informed written waiver. I prepared very lengthy written explanations written to both, explaining the issues that we discussed, any concerns, what could happen, and what we would do in those situations. Both of them willingly signed those waivers. I presented both of them with copies of the relevant rules of professional conduct in Massachusetts, which I believe were rules 1.7 and 1.8. Both agreed, both signed letters, and we moved ahead. The judge was told that this had occurred and that if there were any problems at all in her mind, that I would speak to her ex parte, obviously meaning outside the presence of the prosecutor, and explain and answer any concerns that she had about whether this was waivable, a possible conflict, an actual conflict,
Sure.
and address that. And she never did that. She just ruled that it was a non-waivable conflict, didn't address that issue about speaking to me ex parte, and then I guess, put in her opinion that it was of note that the affidavit for my admission was actually drafted by the sponsoring attorney, which I think is the way it's supposed to be, frankly, as opposed to me filing any paperwork when I'm not yet admitted before that court. And at the end of the day, the judge simply announced that, well, she's got 4 attorneys anyway, and 3 of them are from out of state, so I'm going to deny it. So that's what she did.
Yeah, I remember reading that motion. And the thing is, and we've all noticed that I call her Auntie Bev. You don't have to follow suit, and I'm not attributing that this is your feeling about her. This is my feeling about her. And I feel like Bev is just, because I have no respect for the woman personally. And I feel like this woman, I mean, we've seen it. We've seen it on July 2nd when I have never in my career, and I've had one mistrial myself, and I've seen one in person with a jury where I had a hung jury and my friend had a hung jury, and it was the same situation. The judge asked, how split are you? What are your votes? Are you 5-1 in a district court case? Are you 12-1, or excuse me, 11-1 out of 12 in a circuit court case? And there was never a situation in this case, in Karen Reed's case, where the judge paused the proceedings and said, okay, you guys, let's assess the damage. Where are you? And let's say they would have said, oh, actually, we are unanimous on 1 and 3. Okay, well, I'm gonna, accept your verdict. I mean, I don't know. She has a lot of power at that point. She's the judge. She gets to decide. I personally don't know what the law is. I know that double jeopardy would attach if she were to take the jury's verdict and piecemeal, if you will, and then a new jury would decide charge number 2, and that would be the end of it. But because Bev never actually took that extra step and went, ladies and gentlemen of the jury, can you please tell us what is your split? She left the defense in a very precarious position. And of course, hindsight 2020, I mean, I'm sure Jackson and Yannetti and Little are kicking themselves in the ass going, well, why didn't we ask? Like, can we poll the jury, Your Honor, before they leave? But Bev did it so quickly. She did it so fast. She's like, I'm declaring a mistrial, and I'll see you guys, next week for motion hour. And I remember Jackson was going like, wait, hold on. And then he realized we should have polled the jury before she let them go. She just did it so quickly, so fast, because she is not interested in justice. She is interested in a very particular result, and I find that unique. So the same thing she did to you, I feel like. She's like, this is my decision, and I don't want any more say in the matter. You're wasting my time. You're not going to change my mind. It's basically what she's saying. No matter what you say, no matter what arguments you present, no matter what law you cite, no matter what you try, how you try to convince me, my mind is made up, my decision is made, and it's not going to change. Here it is, and goodbye.
Yeah, I mean, look, I think it's obviously disappointing and troubling in the way it was done, including when it was first offered. Her first comment was, I don't have any real basis to opine on this other than we need a beefier affidavit, which whatever.
So let me remedy that and fix it, and then let me in.
Then what happened was, there was no motion filed in opposition. And then what happens is the prosecutor did what he generally does, which is make a non-objection objection. He doesn't file a response. He gives no notice of any arguments that he's going to make, anything he's going to do. And he then goes on a 10-minute diatribe, essentially impugning my ethics and suggesting that my role was going to be a vessel of communication between
Oh my
Karen
God.
and Aiden to basically pass protected information. And that's why they wanted me there. And, look, he gets the litigation privilege. You can say that in a courtroom, he's protected. But, as a lawyer, that doesn't give you a right to just make up bullshit and,
Yeah.
and just say things. And then at the end say, well, I have no objection anyway. I mean, at the end of the day, they never formally objected. Nevertheless, she just threw it out without the chance to be heard. And I, again, can't agree with it. There's nothing I can do about it.
Sure.
Other than just kind of go forward with, my own situation. I've got plenty to do. I mean, it's not the worst thing in the world. You don't have to, live in a hotel for 2.5 months and deal with this kind of stress. But, I was certainly more than happy to do it, given what the case is and what I think the prosecution is worth and what I think the results should be. And it would have been, very intellectually stimulating and pleasing intellectually and both morally, ethically as an attorney to be involved when she gets acquitted, like I believe she will be. But, it wasn't meant to be. So what can you do?
Yeah. Yeah. So, but it doesn't stop you from working behind the scenes just because you're not a named attorney. Just all that means is you can't stand at the podium in front of the judge on this case. That's all.
Yeah, no, it does. But I mean, look, that's not what I was there to do. I mean, I was
Right.
there to help try the case. So
Yeah.
the reality is they have 4 lawyers now. They'll handle it. I don't need to do that. I certainly support them, looked forward to working with them, but I don't need to be the back office guy. That's kind of not how I roll. I would have been involved in the actual trial. So it's fine.
Fair enough. I can respect that. So that brings me to my next point. If you have any, what are your thoughts about Ms. George joining the fray, former non-deliberating juror in the Karen Reed case?
It's weird. It's odd. It's strange. It's unprecedented for sure. I mean, it's not going to move the needle one way or the other. In all fairness, she's not a criminal lawyer, obviously. She's very, as I understand it, very young in terms of experience, been an attorney for 3 or 4 years, no criminal practice, presumably no trial practice, certainly not at this level. So I don't think I'm making a bold statement by saying she's not there to help try the case. All I can speculate is that she's kind of a resource for, how the jury saw things the first time around. On the other hand, if you're going to pick a juror's brain, I'd be more interested in hearing from a juror who disagreed with your position to see what their thinking was, as opposed to someone who, by all accounts, agrees with them, which is
Absolutely.
good. But I mean, I think there's a lot more to learn from somebody who says, I don't like what you did, or I didn't agree with you on there. So,
And you,
I mean,
you get to find out what and why and how can I fix it for next time.
yeah.
Exactly.
So, I mean, I know, there was a lot of hubbub on Twitter and about this.
Sure.
It's odd. I mean, no one's ever seen anything like this. But at the end of the day, what does it mean? I don't think it means anything, to tell you the truth. It's not going to impact who examines what witness or how we're going to do this or anything like that. Or, she's not going to be picking the jury. She's not going to be cross-examining witnesses. So it's fascinating. It's certainly got a lot of attention. But I
Because
mean,
it's
in
so
terms of
unique. It's like you said, it's never in my life I've ever heard of anything like this anywhere in the world, let alone America.
No, it's crazy. I mean, there's really no other word for it. But when you get past all of that, what impact does it have on what happens to Karen? I mean, I don't think it has any impact whatsoever, good or bad. I just think it's interesting and unique.
Fair enough. That out of the way, obviously, again, I cannot ask you any questions, nor do I want to put you in a very uncomfortable position of having to disclose any information that either TurtleBoy, who is your client, and we owe a duty to our clients, a duty of confidentiality, to protect their interests and to represent them to the best of our ability in order to get them the best possible result. And we cannot talk about active cases. That's why all the videos that I post on my channel are all trials that have ended, cases that are closed. I've had a case that happened before the pandemic, Mark, I'll tell you, right as the pandemic was starting, and I had a really, really, really big beef with the judge. I mean, that content was fire. I couldn't post it for 2.5 years because the pandemic delayed the trial, then other things delayed the trial, and we finally got the trial going. It was already the middle of 2022. So I understand confidentiality better than I'm sure a lot of people, and you certainly understand it. So without just getting into the nitty gritty, I'm just curious, like moving forward, what do you see happening in this case? What are you trying to contribute other than representing Turtle Boy? And anything else you want to tell us?
Well, I mean, I don't have a role with Karen at this point. I mean, I certainly am emotionally attached to their position. I mean, I support them. I believe in what they're doing, believe in her legal team, believe in her innocence, all of that. But in terms of what am I doing? Nothing. I mean, they're trying the case. I'm not, and I'm not going to court to sit there and jot notes and pass notes. I mean, it's entirely conceivable that I would show up for a few days here and there, because I'm coming and going, but that's more of just support and interest than actually doing anything. But I mean, certainly, I'll be rooting for them and hoping they do what they can. I mean, in a perfect world, it would have been great to try a case with Alan and David, people like
God.
that. I'm
dream team.
very much looked forward to that. I mean, I thought that was going to be, given our belief in the client's case, the high profile nature of it, the stakes, everything at issue, the corruption angle, everything else. I mean, this would have been absolutely the kind of case that any criminal lawyer, at a certain level wants to try. So,
Certainly.
But beyond that, now I'm just watching, commenting like anyone else when asked, and that's really it. I mean, I have no role per se, other than just what stuff that we're doing now, talking about it.
Understood. And what about with respect to Turtle Boy? What are the next steps, legally speaking?
Full court press. I mean, the first thing we hope to do is make sure he gets in the courtroom to cover the case and is able to do his show. You'll see something soon about this, but I don't think I'm, breaking news by saying that us, like everyone else, believes that he was put on the witness list as a stunt. I don't think they have any real intent in calling him. I think it's purely to keep him out of the courtroom. And, it's not the first time that this prosecution team has done that with journalists. In other cases, that's happened. It happened in the Whitey Bulger case.
I was just about to ask, did it happen in Whitey's
Yeah.
case?
I mean, they tried that with journalists in that case. Again, we'll deal with that. But that's really the next step in his case. We're waiting for the result on some motions to dismiss in several of his counts of witness intimidation. There's, another new case, as you know, that started a few weeks ago over this alleged incident outside Chris Albert's pizza shop, in which they were allegedly witness intimidating a camera, and then it turns out that there was a second camera there, audio recording, which in Massachusetts is illegal without the consent of all parties, which raises some interesting issues related to his case and beyond. But
right.
That's where his case is going on. But certainly with all that's going on with Karen Reed's trial starting, it tends to take a back seat.
Sure, that's logical, and that makes sense.
Yep.
Especially because both prosecutors who are prosecuting him are going to be busy with Karen Reed. They're not going to have time to do more than just the occasional motion here and there. All of their manpower and force is going to be going towards the Karen Reed case, I imagine.
Yeah, I mean, well, he's got a special prosecutor because, in theory, the Norfolk DA is conflicted out. But
Right.
Meanwhile, the state police are not, which is absurd, obviously. The state police investigator going after him was central to the Karen Reed case, has been subject to much criticism by Aiden. As I said, two of the named alleged victims in Aiden's case are Sergeant Buchanan and, former now disgraced trooper Michael Proctor.
Dishonorably discharged. Somebody corrected me. I said he was fired. And they're like, no, Larry, he was not fired. He was dishonorably discharged. So now I have to start using that phrase because that's what happened. But I mean, It's the same thing. But anyway,
the point is his agency is still heavily involved in going after Aiden. So it's really, lipstick on a pig in terms of dealing with the conflict. So
Sure.
It's a complete mess, but, his cases are just going to plod on, and I don't expect much to happen during Karen's trial. Also because, as I said, the witnesses are part and parcel the same against him. It's all the Alberts, it's the McCabe's, some of the other people, some of the state troopers that we talked about, former state troopers. So, there is some degree of overlap that just can't happen while Karen's trial is going on.
Right, exactly. What are your thoughts about, let's say Turtle Boy is not going to be permitted in the courtroom pursuant to Bev's ruling that you are, on the witness list or whatever excuse she comes up with, because at this point it doesn't matter what the reasons
Well,
are. She just rules and that's it. It
Well,
seems like.
the irony of that would be this, witness intimidation is a hot potato in Massachusetts, and that statute is repeatedly weaponized by the state police and the DA's office, depending on a content-based regulation. I mean, if you're anti Karen Reed, nobody gets charged or done. But if
Right.
you're in favor of Karen Reed, and you make free speech, you throw a rubber ducky around town, you get charged. If you're Aiden, you get charged again, and again. All of these things are going on. The irony is this: Aiden right now is considered a witness in the Karen Reed case because the DA has put him on the witness list.
Right.
We don't believe that's even in good faith.
Right.
We think it's to stifle his speech. Now, if he is in fact not allowed to cover the trial, if he's not allowed to do his show, then I would suggest they're guilty of witness intimidation against him because they are causing him economic harm.
Exactly.
Okay. So the sick irony in this is, where is his rights as a victim of witness intimidation? And I mean, they can't possibly be serious about calling him as a witness to argue that he's going to speak and provide evidence that will establish Karen Reed's consciousness of guilt.
Yep.
I mean, this is, and listen, if you're trying a murder case like this, and this is what you're hyper focused on about her alleged consciousness of guilt because she had the temerity to communicate with him at some point in time, a couple of years ago when all this stuff was going on, if that's what you're focused on, that's probably not a good sign about the strength of your case, because I think there'd be much, much more important work to do than play games with Turtle Boy.
I agree completely. What would you say if Turtle Boy were to not be allowed in the courtroom because of the order, but were still to quote unquote violate whatever? I don't think there's going to be an order. He's just a witness on the witness list. And he does start covering this trial in the privacy of his own home, watching witnesses' testimony, listening to witnesses testify, which obviously you can't do as a witness. What do you think would happen to Turtle Boy if he were to do that anyway?
I mean, that's a hypothetical and a speculative outcome I really don't want to even think about or get involved. Our position is
Fair.
that he has a right as a journalist and a First Amendment right to cover the trial and get in there. And that's what we're focused on. I don't even want to go down the rabbit hole of what if he is literally barred from doing that. He's put on a witness list, he's sequestered, and then lo and behold, never gets called. I mean, which is really what I think would happen here if that's the way this played out. But, we intend to oppose that and will in due course very soon.
I'm certain of it. And I trust you guys, and I'm sure that Turtle Boy is in good hands. I have no doubt about that. And I didn't mean to put you on the spot. I was just curious if you had any opinions on
No,
that.
it's fine.
So, any final parting thoughts? I know I told you that I'd like to have you for maybe like an hour and a half, but you are very succinct, which I appreciate. Two attorneys having an interview with one another, it seems like, well, I guess we can move at lightning speed and cover all the ground necessary. And for the viewing pleasure of the listener, they don't have to sit here for 90 minutes and listen to us ramble about case law and statutes and what rules apply here and there. So any parting thoughts to our audience, Mark? Like anything at all, whatever's on your mind.
No, I mean, look, like anyone else, I'll be interested to see what happens in the next several weeks ahead with Karen's trial. It's as hotly contested as you've ever seen. It's clear that the two parties really don't like each other, which raises the stakes all the much more. But I'm just curious to see how this is going to play out now that the defense has had time to prepare, knowing everything that happened in the first trial, including a lot of these abnormalities. What's going to happen with Proctor. As bad as he was in the first trial, he's now been terminated. If that's not bad enough, he's been terminated for bias against Karen Reed, which is a disaster and fits right into the defense theory. And if that's not bad enough, they've kind of made him the patsy to explain this bizarre issue over missing an undisclosed video. So it's just going to be interesting to see how all of that factors in the next several weeks. But I'm expecting that she'll be acquitted.
Likewise, and I'm hoping that you're right, and I'm sure 99.5% of the audience who's going to be watching this video hope for the same thing. Hello to the 0.5% of you out there. You know who you are.
They're always there. Yeah, no, there's always going to be that.
Exactly. So, listen, Mark, it's been an absolute pleasure. I wanted to thank you for coming on, and I wanted
Sure.
to thank you for agreeing to do this. And I really hope that we get to do this again, number one.
Sure.
And number two, I really hope that I get a chance to meet you in person when I go to Massachusetts. I do plan on being there. People have been asking me, like, Larry, what are you going to do? Are you going to come to Massachusetts? Are you going to stream it? Coming to Massachusetts for 10 weeks of the trial is probably not an actual practical possibility for me. So, because I have a practice to run here in Kentucky, and I can sometimes disappear for a week or two. But last time I went to Massachusetts with Chandler, we learned all too late, unfortunately, that we can't come into the courtroom. It's reserved seating. There are limited seats, and we had to have like special requests that were made. And I was able to get in for one day of the courtroom testimony, and Chandler was able to get in for one day of the courtroom testimony. So visiting Massachusetts in the 10 weeks, if I'm going to be there, it is probably just going to be for a few days, and that is about it. With respect to streaming the trial, I do not plan on streaming the trial as I did previously, meaning from beginning to end at 9 a.m. until 5 p.m. or 4 p.m., however long they go. What I plan on doing is just like the series that I've been covering so far, the Yuri Buchanan series and the Jennifer McCabe series and the Matthew McCabe and the Ally McCabe and all Guarino and Tully and Proctor, all of them that are on my channel either already or will be very soon as I continue to add them every single day. Well, this is what I'm going to do. I'm going to take the opening statements and I'm going to do a succinct, clear, short, curated video for you guys. No fluff, no extras, just pure, unadulterated content. And then when the trial actually starts, we will find all the key witnesses and all the interesting testimony, and I will present you with nothing but the cross-examination portions. Again, no fluff, no fat, just the meat and potatoes of the testimony. So I want to save you guys time. I want to save me time. Right now is a very busy period. I'm getting phone calls from all over the nation of people wanting my assistance. So I do need to address that first because my firm is my baby and everything else comes secondary. Mark, once again, thank you for coming on. Thank you for sharing your opinions. Thank you for supporting Karen Reed. I'm sure a lot of us also appreciate, intelligent people who understand what is going on. And thank you for trying to join the team. And even though it didn't work out, you tried.
Hey, they asked me and I accepted and was ready to go. But what can you do? You can only do what a judge allows.
Exactly. Okay, Mark, I won't keep you any longer. I really appreciate you for coming on, and I will see you guys in the next video. Thank you, Mark.
Hey, take care. Bye.
Bye.